did.
That was entitled Murder on the MMPI Express Use and Abuse of the MMPI in Criminal Minds. Did I read that correctly?
You did.
You mentioned there are two common misapplications of the MMPI test, like the one you performed on John Draft. Isn't that right?
That is.
One of those misapplications was to manually score the test.
Well, I haven't testified that here today.
One of the misapplications you mentioned in your treatise is to manually score the test, correct?
Yes.
That can commonly lead to errors in the results.
Yes.
You manually scored John Draft's score, correct?
I did.
You also mentioned how scores above 60 in the L range reflect the validity of a given test, right?
I did.
And that scores above 60 in this range indicate an error may have occurred in scoring.
I did.
And that the person that is the subject of the test is being dishonest.
Objection, Your Honor.
Well, actually, what it says is that.
Objection, Your Honor.
I'm sorry.
Improper opinion as to the honesty of the subject of the exam. Your Honor, at this point in time, the state has merely changed the word lying with dishonesty. So a previous argument as to the lying is really where we're at here, but we have just changed the word from dishonest to honesty. Again, there is no test or no expertise that can allow a witness to stand on the stand and state that someone is being dishonest or honest. They can merely put the facts into the record that draw the inferences that he may not have been, but they cannot state on the stand as well.
Your Honor, defense motion in Lemonade prevented anyone from referring to the L scale as the lying scale. That has not occurred here, and to say that this scale indicates that someone is lying is also not calling it the lying scale. It is an indication as to exactly what it indicates.
Are we talking about the L scale here?
Indeed we are.
That needs to be clarified a little bit, what we were actually discussing. So the question again was
that scores above 60 in this range would indicate, not conclude, but indicate that the subject is being dishonest.
and that was in fact what's written in this Exhibit 7, which was not identified for the court. Is that right?
Your Honor, may I be heard on that?
You may. I just want to make sure I understand.
It is Exhibit 7, but that cannot be found in Exhibit 7, Your Honor. Exhibit 7 states that the L scale measures a subject's rigid adherence to moralistic attitudes.
I'm sorry. Can someone ask?
Second paragraph, top column,
Thank you.
first full paragraph. In that particular respect, if counsel was suggesting that this is the basis of his question, it's also a mischaracterization of the testimony.
Your Honor, this is based on testimony earlier elicited from Dr. Chris Chacona, which has already been submitted to the record.
And what is that?
That the score above 60 in the L range indicates that the subject is being dishonest, or it indicates that they are lying. While he was prevented from using the term lying scale, he did say that the L scale above 60 indicate an error in scoring because of that.
Your Honor.
I don't recall that testimony at all. I don't recall the doctor saying that. I'm sorry, the defense was here.
Oh, no.
I will sustain the defense.
Thank you, Your Honor.
So you mentioned that scores above 60 indicate that the person being subjected to the test has rigid moralistic attitudes and are repulsed at even the most common human faults.
Objection, Your Honor. This is vague and ambiguous. There are 3 different scales which there is language regarding the levels of those scales. I merely ask that the question be more specifically geared towards the L scale, if that is what counsel is trying to elicit testimony.
Your Honor, prior to the objection arguments before, this was directed solely at the L scale. The question prior to the objections was regarding solely to the L scale.
Let's start the question from the beginning.
If you'd like, I can loop this for the jury. You also mentioned that scores above 60 on the L scale indicate that the subject has rigid moralistic attitudes and is repulsed at even the most common human faults.
I did.
You also mentioned here in your treatise that scores from 30 to 35 in the K scale are found in persons who have either fabricated or greatly exaggerated their problems to create an impression of a severe emotional disturbance. Did I read that correctly?
You did?
K scale indicates a score of 35 here, correct?
Yep.
And this scale is referring to the defendant, John Draft.
Yes.
You mentioned you spent 10 hours with the defendant. Correct?
I spent over 10 hours with the defendant.
During each of those 10 hours, you were being compensated, correct?
I was.
During that 10 hours, were you ever able to inquire as to the defendant's medications?
No, I did not ask the defendant as to his medications.
You didn't ask him about his family history of mental illness?
I did speak with him about his family history, yes.
It's your testimony that you spoke with the defendant about his history of mental illness.
No, I didn't say that. I said I spoke with him about his family history.
Is it your testimony that you spoke with him about his family history of mental illness?
I spoke with him about his family history with his family as it pertains to his divorce and the grounds for his divorce and his relationship with his daughter.
Thank you, Dr. Johnson, but the question was about his history of mental illness within his family.
I did not discuss his history of mental illness within his family.
And over your 10 hours with the defendant, you also mentioned you reviewed exhibits,
I did.
reviewed testimony,
I did.
conducted your MMPI testing,
I did.
and you concluded that John Drath had a mental disease or defect.
I did.
However, you weren't able to give a name for that mental disease or defect.
I'm sorry, I don't understand your question.
You were not able to come up with a name, or nail down a name for the mental disease or defect that you claim the defendant has.
You mean a more specific name other than that he's mentally diseased?
Yes.
No.
Now, you also believe that if the defendant were sane, he would have gotten rid of his weapon, tossed it away.
That's true.
But you don't believe he did that.
I don't believe that he got rid of his weapon?
Correct.
No.
That's because, as you understand it, he put his gun in his safe.
Yes, as I understand it.
And that after returning home from shooting the victim, he cleaned his gun.
Would you raise this, counsel?
Mischaracterization of the evidence.
I'm not sure we've heard any evidence about this, so. Steve?
Oh, again,
Also-
unless I'm being
also
way
the
much.
ultimate issue.
Well, let me, go, I'm sorry.
You know, this is based on statements made by the defendant that Dr. Johnson has full awareness of and was able to hear during her 10 hours of working with the defendant.
You know, in that particular case, we have no foundation for where these particular statements have come from or when she had opportunity to hear this, under what conditions.
That seems to be a bit out of left field. How about we try some more foundation questions?
That's right. In speaking with the defendant for the 10 hours you mentioned, he told you that he cleaned his gun.
Yes.
He told you that he returned home from the victim's house and cleaned his gun.
Yes.
And that after that, he put his gun in his safe.